I'm glad you could join me here at Clackamas Community College. I'm standing in front of our Faces of the Fountain. The college chose 18 influential people, and I'm standing in front of Chief Joseph of the Nez Perce Band out of Oregon. Today, here at the college, some of the students are going to do a mock appeal to the Supreme Court of the United States based on a case involving Chief Joseph and his band of Nez Perce and the Wallowa Valley out in eastern Oregon. The case is based on an appeal of a 1941 case before the U.S. Court of Claims. The descendants of Chief Joseph and his band of the Nez Perce took their case of an invalid 1863 treaty to the Court of Claims, arguing that it was an invalid agreement. The court held for the government in the case, deciding that it was a valid agreement and that Chief Joseph and his band did not have a claim of title to the Wallowa Valley. And so that's what this appeal is based on. They had a very good argument for lack of agreement, but we've had additional considerations since that 1941 case that make this a very appealable case. So in a few minutes we're going to go inside and begin the mock appeal. It is really called a moot court competition. Harvard Law School is famous for their moot court competitions before the U.S. Supreme Court, so we're kind of doing a similar thing and hope to show that Harvard has nothing on Clackamas Community College. But before we go in there, I do need to give you a little bit of background about how the treaty came about and some of the facts behind this case. So let's take a moment and let me share some of that with you. Our story goes back to an original 1855 treaty signed between the Nez Perce as a tribe and the United States government at the time that the government was trying to make treaties with most Native American tribes. The cultural background of the tribes back then was an autonomous existence. They had individual bands, and each band would have their own individual territory that was recognized by all the other bands to be their rightful territory. And with the Nez Perce band, the Wallowa Valley was the independent and exclusive territory for Chief Joseph and his band of Nez Perce. So the government came in and negotiated an 1855 treaty that included the valley and about 7 million acres of land in eastern Oregon, a little bit of Idaho, and a part of Washington. And in that 1855 treaty, Chief Joseph was recognized as having the exclusive right of title to the Wallowa Valley, and he signed the overall treaty. About 8 years later, after the discovery of gold, the government came and wanted to negotiate a new treaty in 1863, taking back 90% of the land, about 6.25 million of the acres back, giving the Nez Perce tribe as a whole only about 750,000 acres, and it would not include the Wallowa Valley. The government worked hard to get Chief Joseph to agree to this, but Chief Joseph and many of the other tribal chiefs walked out in protest and rejected the 1863 treaty. What the tribe did was get signatures from a lot of other band members, and the government decided to kind of do an end around and accept those signatures and consummate the 1863 treaty. The treaty was ratified by Congress in 1869. Chief Joseph Band did not move out of the Wallowa Valley during that time between 1863 and 1869 and wouldn't be actually evicted until 1877. And in between that time, old Chief Joseph died in 1871 and his son, also named Joseph, took over. That would be referred to as young Chief Joseph. And he would continue to argue their lack of mutual agreement and got enough people in Washington to agree with him that President Grant in 1873 signed an executive order creating an individual reservation for Chief Joseph's band encompassing the Wallowa Valley and giving him exclusive title. But there was pushback from Oregon's governor and congressmen and lots of other people from the settlers who had found the gold. And so, unfortunately, President Grant signed a second executive order wiping away the reservation. And so the fight had to continue. Then in 1877, 14 years after the 1863 treaty was negotiated, the government gave young Chief Joseph's band 30 days to move to a reservation in Idaho. Chief Joseph's band decided not to go to the reservation, and so the Army pursued them as they tried to flee to Canada to join Sitting Bull's band that had sought sanctuary in Canada. The Army pursued them very hard, and yet young Chief Joseph was able to evade the Army for 1,100 miles, but was caught 40 miles short of the Canadian border, where young Chief Joseph surrendered and said his famous words, "I will fight no more forever." He was then put into a reservation in Washington, and the rest of his band was put on the reservation in Idaho. And young Chief Joseph continued to argue his case for lack of agreement against the 1863 treaty until he died in 1904, many say of a broken heart. That's where the descendants of the band carried on the argument that led to the 1941 court case that we're about to watch the mock appeal for. So that gives you enough background to understand what happened all the way leading up to the appeal. And then the other important information is to know that this appeal is based on an argument that the 1863 treaty was not valid because it did not have Chief Joseph's signature on it with respect to the Wallowa Valley, and that Chief Joseph did have a claim of title to it, and that when they made an offer to him as an offeree, he had contractual rights that they violated, creating a lack of mutual agreement. Those are the three issues being appealed. So without further ado, let's go on in and watch the mock appeal. This is the case again of Chief Joseph's band of Nez Perce versus the United States, and it's the appeal from a 1941 case before the Court of Claims, and you appeal directly from the Court of Claims to the Supreme Court, and that's why we're here today. And there's three issues at hand in the case today. First, the petitioner claims that the court erred when it held that the one entity approach to consummation of the 1863 treaty rendered it a valid contract by denying Chief Joseph's band their basic contractual rights. Number two, that the court erred when it held that Chief Joseph did not have an exclusive claim of title to the Wallowa Valley based on cultural considerations and the true intent of the government. And then number three, the court erred in not holding that there was a lack of mutual assent between Chief Joseph and the government, resulting in an invalid agreement. So those are the three issues at hand, and so let's go ahead and get started. All rise. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Petitioner, are you ready?
Good morning, everybody. Thank you for joining us here today. We are arguing on behalf of Chief Joseph in terms of the Walla Valley. We would like to go ahead and note that this contract between the United States government and the Nez Perce as a whole was an invalid contract due to the privity of the title of land owned by Chief Joseph. We hold that the court erred when it held that the one entity approach to consummation of the 1863 treaty rendered it a valid contract by denying Chief Joseph's band their basic contractual rights. The one entity approach ignored the contractual rights afforded Chief Joseph and the autonomous rights recognized in the 1855 treaty. The contractual rights. Privity was established when an offer was made specifically to Chief Joseph regarding the Walla Valley, thereby recognizing this band's claim of title outside and independent of lawyer and the rest of the Nez Perce tribe. In Davis v. Wells, decided by this very court in 1881, making it especially relevant, states, the agreement to accept is a transaction between the guarantee and the guarantor, and completes that mutual assent necessary to a valid contract between them. It establishes a privity between them and creates an obligation. Privity was established with Chief Joseph directly, and lawyer was not involved in any of the negotiations or discussions between the government and Chief Joseph regarding the status of the Walla Valley. Your Honors, this is perhaps the most important element. The Nez Perce members that lawyer gathered for the 1863 treaty lacked privity regarding the Walla Valley. Only Chief Joseph could accept the offer presented to them. Section 52 of the Restament Second of Contract states, who may accept an offer? An offer can only be accepted by a person whom it invites to furnish the consideration. There is no stronger evidence that Chief Joseph was the only person the government originally believed could accept the offer regarding the Walla Valley than the fact that they weren't evicted from the valley for 14 years, during which time the government continued to negotiate directly with Chief Joseph. This privity is further proven by the 1873 executive order returning the valley back to Chief Joseph's band as a mini reservation. Autonomous rights of ownership was recognized by the government, further proving privity of contract. The government recognized the rights of the autonomous bands and individual ownership of territories with the 1855 treaty, and most specifically, Chief Joseph's right to the Walla Valley. The government touted the success of getting the individual chiefs of 53 out of 58 bands to agree to the 1855 treaty as proof of its validity and as an example for future treaties with other tribes. The touting shows the government recognized the autonomous claim of title each band had in its own territory within the overall reservation. That is precisely why they deliberately sought assent from Chief Joseph regarding the Walla Valley for the 1863 treaty separate from lawyer. With the 1863 treaty, the chiefs of 53 of those 58 bands who signed the 1855 treaty were present for the negotiations, but 27 of those 53 chiefs that signed the 1855 treaty walked out in protest, rejecting the terms of the 1863 treaty, including Chief Joseph himself. Lawyer was able to garner signatures from random members of other bands, none of which had actual title to the land they were negotiating for. As stated, the Nez Perce members that lawyer gathered for the 1863 treaty lacked privity regarding the Walla Valley. The government only changed the one entity argument for the 1941 court case, which completely sidesteps the privity established between Chief Joseph and the government that created an obligation as set out in the Davis case decided by this very court. The court erred additionally when it held that Chief Joseph did not have an exclusive claim of title to the Walla Valley. Original title was established in Chief Joseph's band. American Indians were considered by the U.S. law to have original title, subject to the authority of the federal government and protection of the Fifth Amendment when the U.S. Congress recognized the right to title through a treaty or by other means. I'm so sorry.
Go ahead.
Okay. Chief Joseph's band received this recognized right with the 1855 treaty when it was ratified by Congress. The government further recognized the rights bestowed by Congress to Chief Joseph's band to title of the Walla Valley in its Army report. Statements by General Howard and CES Wood, and both Monteith and O'Donnell, agents of the government. The executive orders signed by President Grant carved out a separate reservation specifically for Chief Joseph's band that is written proof of the government's recognizing the rights to title of the Walla Valley in Chief Joseph's band. This recognized right to title by Chief Joseph's band was recognized by the U.S. government dating back to the band giving aid to Lewis and Clark's expedition. Finally, the court erred in not holding that there was a lack of mutual assent between Chief Joseph and the government that resulted in an invalid agreement. There was a lack of mutual assent because an offer was made specifically to Chief Joseph regarding the valley, recognizing his claim of title outside and independent of lawyer, and his separate representation of the tribe as the main point man. This court has already recognized in Davis v. Wells that contract law protects the original parties to an offer and acceptance that create an obligation once privity is established. Mutual assent was required by Chief Joseph throughout the negotiations of the 1863 treaty and the subsequent 14 years of occupation. But Chief Joseph's band rejected the offer. Chief Joseph's rights were denied when he rejected the offer, and the government used a loophole to circumvent Chief Joseph's legal title to the valley through an invalid agreement that did not include any authorized signatures on behalf of Chief Joseph's band that could furnish the consideration. This court is asked to strongly consider Section 52 of the Restatement of Contracts with respect to the evidence and testimony presented in this appeal, where the court can only conclude that the offer can be accepted only by a person whom it invites to furnish the consideration. Additionally, the Fifth Amendment Takings Clause would not apply here. This case is distinguished from the Sioux Nation versus the United States case, where this court held that any argument against the treaty involving the Black Hills was moot because the government could have taken the land by using the Fifth Amendment's Taking Clause. With this appeal, we argue that different than what happened with the Sioux Nation, there is proof that the government did not pursue a Fifth Amendment Takings Clause in a timely fashion intentionally. When Chief Joseph rejected the offer with the 1863 treaty, there was plenty of time to exercise the Fifth Amendment's takings, but Congress chose not to pursue this remedial effort when it was ripe. Chief Joseph's band was not evicted for 14 years, during which time an executive order even granted the valley back to Chief Joseph, proving that Congress never intended to use the Fifth Amendment Takings Clause. When Chief Joseph rejected the offer, it stands to reason that was the time to assert the Fifth Amendment's Taking Clause, and the decision by the government not to assert it at the time proves it was a deliberate move. In closing, Your Honors, we respectfully request that the 1863 treaty with respect to Chief Joseph's band and the Wallowa Valley be held in an invalid agreement, and that all lands known as the Wallowa Valley at the time of the 1863 treaty be restored to the descendants of Chief Joseph's band.
If Chief Joseph agreed to one title to the reservation in the 1855 treaty, then did he not agree to an uninvited interest in the land, similar to what he held in the Sioux Nation case?
Excellent question, Your Honor. We believe that there is a difference between the two groups of this Sioux Nation versus the United States and this very case here. In the case of the Sioux Nation, it was the entire band of the Sioux Nation fighting against bad faith as a one entity. In this case scenario, we are going specifically with Chief Joseph's band. This is only 2/7 of the entire valley. This is not one entity. This is in fact Chief Joseph being argued upon this question. And in the case of this, the rest of the valley, apart from Wallowa, had no privity to this case. This is a unique case. In the case of Sioux Nation, they all had privity as they all acted as one in this case scenario. Thank you.
Why was the lawyer able to get the signatures and convince the government it was enough to represent the whole tribe?
I'm not certain why the tribe members were willing to betray their own bands for a lawyer. It is possible that they sought to be regarded as a new title holders for the land and not in their possession. It could only be that they did not have faith in the people that were fighting for them. There's a good chance that they did not fully grasp what it was that they were signing. Regardless of their reasoning, none of them had the appropriate ownership to sign the document. I believe that the government knew this to be the case, which is why it led into pursuit of Joseph alone for 14 years after the 1863 treaty had all of those credible signatures. It is simply illogical to think that the member of the various bands could give away the entire Wallowa Valley after the 1855 treaty made sure to have that the band leaders. Not only that, why would any other signatures at all? If the Nez Perce could be negotiated for by one person, why would they need the government to get anyone but them to sign? But when you're considering the potential of the resources that the land that was owned by the Nez Perce could yield for your great nation, you might choose to ignore your own laws.
Why did Chief Joseph walk out, and doesn't that mean he gave up his right to the title of the land by walking out?
Your Honor, I may purchase a favorable decision from you. I'd be more happy to pay you $1 for your corruption. Now, as ethical justices, I'm sure you're down to turn down such an offer. In fact, that you might be dismayed by the prospect that you'd leave the room. Who knows that you might even find after insulting Joseph that he was certainly, certainly insulted by the government's offer. He walked away saying no words enough to convey the amount of insult he felt at the time. After all, actions speak louder than words. In the case of young Chief Joseph Jr., he had a quote. Regarding privity towards this. Suppose a white man could come to me and say, Joseph, I would like to buy your horses. And I would say, no, I like your horses and I want to buy them. To him, I would say, no, my horses suit me, I will not sell them. Then goes to my neighbor and says to him, Joseph has some good horses, I want to buy them, but he refuses to sell. My neighbor answers, pay me money and I will sell you Joseph's horses. The white man returns to me and says, Joseph, I have bought your horses and you must now let them have me. If we sold our lands to the government, this would be their way that they bought it, by going through a lawyer.
Why was the original intent of the Nez Perce in entering into the 1855 treaty, and why did they agree to any takings of their land to begin with?
Chief Joseph was doing any bright leader would. He would be seeking peace with his neighbors. Joseph knew that there could be a diplomatic way to solve the issue of these foreigners' expansion into their lands. Rather than go to war with the East, he sought a treaty that would benefit both groups of people. Even he knew that sometimes you might give a little to get a little. Due to the more reasonable conditions in the 1855 agreement, the bands all signed their parcels of land in unison. In doing so, each of the band leaders were establishing in writing that they should be considered to the ones who own the sections of land as per cultural considerations.
If you say Chief Joseph had title to the valley, then why is that not reflected in the legal description of the 1855 treaty?
It becomes a more complicated matter when you go ahead and take the treaty into consideration. You have to bear in mind that the treaty, while being signed by Chief Joseph in 1855 and then not signed in 1863, makes for a very interesting situation when it comes to the autographs on the paper. However, the real issue about privity is the fact that by the government prior to the 1855 treaty even being signed, sought out Chief Joseph to go ahead and negotiate on behalf of the lands. They are creating the privity that he is the only party that can furnish the consideration for which they seek. Meaning that regardless of whether or not it is specifically laid out in the documentation of the treaty itself, they have established that Chief Joseph is the rightful property owner. As a result, they can go ahead and say that they had somebody else sign on his behalf, but at the end of the day, he is the only one that has any claim due to the privity they established before either of the documents were signed.
With respect to privity of contract that you say created an obligation to Chief Joseph with the 1863 treaty, didn't he cancel the obligation by walking away from the negotiations?
Well, as we previously discussed, there is the small matter of what it actually means to leave the negotiations. Now, you could make the argument that him leaving is him surrendering. However, I think that is a misguided direction to work in. In fact, I think that, as Hunter said, actions speak louder than words. When somebody offers you something so insulting that you can't even stomach to be in the same room as them, doesn't it say an awful lot more to merely walk out as a rejection of their offer as opposed to simply saying no? I do not think that he walked out to surrender his lands. I think he wanted to make it very clear how he felt about the offers that were being made by the U.S. government.
Why was it not established on record that each representative of the individual bands of the Nez Perce had individual title to their share of land in the 1855 treaty?
I believe that question goes straight back to privity. Within the 1855 treaty, it established the autonomous rights of the Nez Perce as a whole in the valley. Outside, we are talking about the Wallowa Valley. We're not talking about the entire valley as a whole. Because we are talking about the Wallowa Valley and the Wallowa Valley alone, we are recognized only to Chief Joseph, who is the sole title holder of this land. Any other signatures towards the 1855 or even 1863 agreement are irrelevant to this case as they do not pertain solely to the Wallowa Valley.
What makes this case any different than what we held in the Sioux Nation case, where we held that the tribe signing as one entity was acceptable and there was no breach of contract by the government?
It is always helpful to seek guidance to prior court's decision. If it hasn't already been decided, then there's a guidance to how you should handle the facts in subsequent cases. Unfortunately, this case is not like the Sioux Nation case. The Sioux Nation case was a one entity arguing in bad faith, as we stated earlier. This is an argument of privity towards who had title to the land. As we've stated many times before, the lawyer does not have privity to the Wallowa Valley. He may have been the face of the one entity, but the one entity does not apply in this case scenario, as it is solely Chief Joseph who we are saying has privity.
Why should this court now hold that the agreement is moot? Because the government could have used the takings clause under the Fifth Amendment, like we decided in the Sioux Nation case.
This case is unique in that while the Sioux Nation was governed by one body, the Nez Perce operated as autonomous bands within the region. Not only that, the length of time that Chief Joseph led his band even further than reinforces our point that he was culturally the owner of the Wallowa Valley.
Moreover, they failed to go ahead and seek a Fifth Amendment takings clause in a reasonable amount of time. For them to wait at least 14 years to go ahead and finally evict the Nez Perce from their land and still not pay them for it is a very confusing and obviously deliberate decision. It's very clear that they did not think that the takings clause would apply in this particular case, because if it were to, wouldn't it have been easier to go ahead and simply pay Chief Joseph's band to leave the territory?
Are the respondents ready?
Yes, Your Honor. May it please the court on a less lengthy note that we, the respondents, disagree with the petitioner and respond with 3 key points. First, in the 1963 treaty, the court held that one entity approach to the Nez Perce created a valid contract. Second, in both treaties, Chief Joseph was never allotted a divided interest in the reservation or given an individual title, so that the court was correct in the assumption of an undivided interest when it came to the 1963 treaty. Thirdly, and most importantly, Chief Joseph's contractual rights were not at issue because at the time he had no independent rights due to the 1855 treaty and the fact that Indians at the time were not considered citizens of the United States, leaving them no independent rights until 1924.
Why did the government use opposite reasons for validations in the different treaties? They said that the 1855 treaty was a unanimous agreement and that was the reason for the validation of the agreement. But in the 1863 treaty, only a small majority signed. Why was that an appropriate validation for that treaty?
Well, you see, Your Honor, it was not a small majority. 51 out of 53 bands did sign. In this case, it is simply Chief Joseph, a prideful man, being the minority in this vote, throwing a tantrum.
With the 1863 treaty, after 27 chiefs walked out of the negotiations, why didn't the government go back to those 27 bands and find a different head person or representative for the band?
Again, the 1863 treaty was 51 out of 53 bands signed. So I ask, where is this 27 number coming from?
I have 2 questions. So why was the government hounding Chief Joseph for 14 years after the 1863 treaty if they didn't believe he had title to the valley?
Again, Chief Joseph was upset that he was the minority in a majority vote. Therefore, he was upset.
Yes, but why? Why was he so special? Why did they spend 14 years going after specifically the Wallowa Valley?
Well,
and why did they chase him down 1,100 miles to Canada just for his title?
He had no title, although because he was making the most racket out of, again, the minority of 2 bands who didn't sign, they seeked to appease him in hopes to come to peace with him, where the government was not trying to create conflict until he decided to go about his ways and do what he will. In that case, we did see conflict.
Did he really though? Did he really make such a big fuss out of all the other bands that were there?
Why would we focus solely on him if he did not?
Because why just him? There were 27 other bands that walked out with him that made just as big a fuss, so why specifically him?
Again, I asked where the 27 came from, and I remind you that 51 out of the 53 bands signed.
Was a privity established with Chief Joseph when the government made a direct offer to Chief Joseph without lawyers' involvement or presence?
Referring back to your previous question, the government was trying to appease Chief Joseph in person, and that is why they contact him individually. But this did not mean he had any individual rights to any land, simply trying to appease an upset person.
But for cultural considerations, he did indeed have right to that land.
I disagree, Your Honor. Nowhere in either treaty was he specifically named, and that is why both treaties are unanimous.
But wasn't it in the 1855 treaty, weren't they all given cultural consideration of each individual band's part of land?
We did extend cultural considerations to reservations, as they did not have any rights to the land. That answers your question, Your Honor.
Was the government intent behind the offering of the 1863 treaty different than the government intent for the 1855? If so, how and why?
Your Honor, I don't believe so. I feel that in both treaties, the government had information on systems that worked and did what they could to incorporate and educate the Indians at the time.
Additionally, the government was so kind to offer a treaty at all. As previously noted in conversation, the government could have decided to pursue war against the nations if they so chose to, but not only that, but secondly, they extended a version of the Fifth Amendment rights, which again, the Native Americans were not citizens, so they did not have rights to. So your final answer, Your Honor, is no, there were no cultural considerations.
Doesn't the executive order signed by President Grant in 1973 returning the Wallowa Valley back to Chief Joseph's Band as an independent reservation preempt any attempt to legitimately claim it would have been the intent of Congress to pursue a Fifth Amendment taking?
As I'm sure the court is aware, an executive order in order for an executive order to be valid, it must be backed by 2/3 Senate votes, which this executive order did not have. Therefore, the executive order is null and void, Your Honor.
Would you have this court ignore the tenet of contract law where this court held in Davis v. Wells that privity creates an obligation?
I'd like it noted that the David versus Wells court case was in 1881, and we are considering things from 1855 and 1863, which means that the David versus Wells would come far after this court would establish their original rulings.
I have 3 questions. The first being, as you stated, Native Americans were not considered American citizens until the 1900s. How would American laws apply to them? Wouldn't the Fifth Amendment takings not apply to this circumstance if they were not citizens of the United States?
The Native American Citizen Act was enacted June 2nd of 1924. Therefore, you're correct. The Native Americans did not have any Fifth Amendment rights. However, as I mentioned previously, the government was kind enough to extend a Fifth Amendment right, in a sense, through these treaties.
Shouldn't the treaties have been treated as a barter between 2 separate nations as rather than part of like a Fifth Amendment taking under the government?
Yes, so a treaty is for 2 separate nations. So, but because these nations were so close together, we decided to, rather than create conflict, try to create peace, which is why the treaties were created in the first place.
Why didn't the government simply pursue a Fifth Amendment takings when the negotiations with Chief Joseph failed for the 1863 treaty?
Because he was not considered a U.S. citizen until 1924 Act that made all Indian citizens. The 1863 treaty was actually an attempt to give the divided land to each individual person over the age of 21, which would have given them citizenship.
Why was no Fifth Amendment takings pursued through Congress between the 1863 treaty and the eventual eviction in 1877 of Chief Joseph's band from the Walla Walla Valley?
Again, they were not citizens, so the Fifth Amendment takings was not a full Fifth Amendment's takings. It was an extended Fifth Amendment.
With so many government officials expressing at the time that Chief Joseph had a recognized title to the valley, how can you honestly claim he did not have title to the valley?
There is no written proof, and this is just hearsay.
I have two questions. The first one is, what makes lawyer qualified to solely represent and negotiate on behalf of Nez Perce in the 1863 treaty?
The fact that he signed the 1855 treaty, Your Honor, is the reason why. If he had not signed the 1855 treaty, then we could understand that maybe he didn't want lawyer on his behalf, but because he signed it with knowing that lawyer was represented as the head chief on the document itself, that it gave him the right.
Was lawyer the government's choice as head, or was he elected by the tribe members?
Your Honor, I don't know if there was an official election by the tribe, but by signing the 1855 treaty again, they did not protest or walk out of that contract, which would indicate that they were knowingly signing away that their rights to lawyer and letting him represent them.
Does Chief Joseph have a final rebuttal?
Yes, Your Honor, we most certainly do.
Yes.
Now, we've heard an awful lot today about why it is that these not citizens, where we can apply rules as we want and then not when we don't want to, are not and also simultaneously still allowed to be treated however the government really wants. And what this really boils down to is the government choosing to go ahead and seek out the resources owned by the Nez Perce in an attempt to go ahead and bolster their own economy. They were stealing from these Native Americans and trying to go ahead and hide it under the ruse of a one entity that could simply sign it all away in every subsequent document after the 1855 agreement. The United States government offered to make an agreement with Chief Joseph pertaining to his land. At that moment, they established the privity that Chief Joseph was the title holder. Regardless of what happens in any subsequent documentation, it doesn't matter. The privity was already established. He was a recognized title holder. So much so that I am sure that the government, after realizing that these 53 different band members went ahead and signed the 1863 agreement, half of them were not even the original signers of the 1855 agreement, bringing to question whether or not they were actually qualified to speak on behalf of the tribe at all. And to go ahead and coincide with that, because they operated one way in the first contract, does not mean they have to do so going forward. Lawyers spoke for them in the 1855 agreement, but seeing as they're all individual title holders, he can't simply speak for them throughout the rest of history. He has no claim to the land. They would have to work in unison. And seeing as I don't see Chief Joseph's ratification on that document, I just don't see how it's valid. He's the title holder, yet he's not on the piece of paper.
Therefore, the Wallowa Valley is within the United States, and they were born and naturalized within the 14th Amendment. They are therefore citizens of this land. Therefore, say 1924 is the improper year, and that way, if they were evicted in 1877, they should be paid at the very minimum, and their land should be returned to them immediately.
We will now go and make our decision.
All rise. All rise.
The petitioner contends that the Court of Claims erred in its holdings that the 1863 treaty was valid and the Nez Perce tribe signed the 1863 treaty as one entity when it came to the specific territory known as the Wallowa Valley. Petitioner further contends that the Court of Claims erred with regard to Chief Joseph not having a recognized title to the valley. Petitioner also contends that the Court of Claims erred when it ignored the contract principle of privity that creates a legal obligation. First, we examine the factual findings with respect to the signing of the 1855 and 1866 treaty, and this court finds that the signatures gathered for the 1863 treaty were not sufficient to make a valid agreement with respect to the conveyance of the Wallowa Valley. When applying the cultural considerations together with the near unanimous agreement of all bands with the 1855 treaty, it is difficult to reconcile that the government's argument with the 1863 treaty that relies on a simple majority that completely ignores the autonomous ownership by bands recognized in the 1855 treaty. This court agrees with the petitioner in that the government deliberately used a loose loophole to sidestep the autonomous nature of the Nez Perce tribe recognized in the 1855 treaty. Second, the court found that after engaging in this exhaustive review of the historical record, that Chief Joseph's band had a legally recognized title to the Wallowa Valley. The evidence is clear that the intent of all parties involved support the claim of ownership to the valley. We see this in the testimony of the Indian agent of the government, from the lead negotiator, General Howard, and from the Army report commissioned to determine this issue. The strongest evidence supporting this conclusion, however, comes from the executive branch of the government by issuing an executive order carving out a new reservation for Chief Joseph's band. Third, after a thorough review of the contractual considerations, this court finds that the rights granted Chief Joseph when the government established privity were violated. In Davis v. Wells, this court held that privity is established on an obligation is created by both parties that cannot be extinguished by ending negotiations and simply moving to a new offeree. The government established over and over Chief Joseph's right to title through exhausting attempts to get him to agree to the 1863 treaty that stretched out for over a decade and a half. The evidence is overwhelming, and the contract rights were created and then violated. In sum, we conclude that the legal analysis and factual findings of the court and claims were in error on all three counts and do not support its conclusion that the 1863 treaty was valid with respect to the conveyance of the title to the Wallowa Valley. We find that the Fifth Amendment takings clause does not apply in this case based on the evidence that the executive order signed by President Grant returning the valley to Chief Joseph. As we note in our decision in the Sioux Nation case, President Grant supported the Fifth Amendment takings of the Black Hill in the exact same time he was rejecting it for Chief Joseph in the Wallowa Valley. This evidence of the opposite position taken, President Grant proves that a Fifth Amendment takings was not the desire of the government when it came to the Wallowa Valley, and further, that the government recognized Chief Joseph's band as having title. Therefore, the judgment of the court claims it's overturned and is hereby ordered that the Wallowa Valley be returned to Chief Joseph's band of the Nez Perce. So it is ordered.
Wow, wasn't that fantastic? I thought the students did an amazing job. It was a tough decision at the end, you could tell. Both sides put up some really good arguments. I am so proud of our students and the job they did with this appeal. I can't even believe it. But I think what was more surprising to me was the decision. I had no real idea how the court was going to decide, and for the students to all decide in favor of Chief Joseph and a return of the complete Wallowa Valley to Chief Joseph's band is just amazing. It shows the potential of this appeal, doesn't it? So thank you for taking the time to watch this, and if you want more information, you can go to a website I've set up for my students for this assignment called chiefjosephappeal.com. On a personal note, I'd like to talk directly to the descendants of old and young Chief Joseph and say, I am truly sorry for what America did back then. And I hope this mock appeal and the article that's on the website generates more interest for an appeal. And I just want you to know there are some of us out there still pulling for you to get your valley back. Thank you.